People versus Moss.
Good afternoon. May it please the court. Dave Juergens, Monroe County Public Defender's Office for Dwight Moss. Could I reserve 3 minutes, please?
Yes.
A coerced guilty plea is not a reliable indicator of wrongdoing. If a judge tells a defendant, you can take the people's offer 7 years, or you can go to trial. Let me tell you what happens if you go to trial. If you go to trial, you're either going to be acquitted and you can walk, or you're going to make me happy and I can give you the maximum punishment, which in this case is 50 years, which was erroneous. There was a resentencing proceeding in this case by the appellate division.
Why isn't his recourse to argue for a downward departure, which he didn't in this case? Might have gotten him the outcome he wanted, but he didn't in this case. Why isn't that the appropriate procedure?
Because he had...
Conviction is a conviction. You didn't vacate it, but if you wish to argue that that conviction should not lead to a level 3 or even a level 2, make your argument on a downward departure.
Because the coerced guilty plea in this case was presented to the Monroe County Court as a reason not to find that the override is applicable. And that's based upon a reasonable interpretation of the guidelines. And I think it's important to emphasize in this case that the board, there's no deference here. The board
Well, it says conviction, right?
Pardon?
Guidelines say conviction, correct?
Guidelines say
Okay.
conviction.
And it is a conviction.
And it is a conviction, absolutely.
So
It's,
why is
but
it reasonable to now add language into the guidelines?
Because for the board was authorized to come up with procedures and guidelines to accurately assess the risk of a sex offender, the future risk.
So do not the acts underlying this conviction, would that not assist the board in assessing and determining what the risk factor is?
And that would be appropriate should the people seek an upward departure based on the underlying conduct. This override provision just relies on the mere fact of conviction. And Mr. Moss established by substantial evidence, I would say even beyond a reasonable doubt, at the resentencing proceeding, that this mere fact of conviction is not a reliable indicator of wrongdoing.
Could he move to vacate the conviction?
Pardon?
Could he move to vacate the earlier conviction?
Well, Mr. Moss may have had a problem in this case because he did try to, his attorney never filed a notice of appeal. He did apply for filing a late notice that was denied by the appellate division, and then under the CPL 442C,
Did he ever move to try to vacate that conviction?
to my knowledge, I'm not aware of a 440
So it
motion.
seems like all the collateral effects from that conviction go away if we do this, particularly the Sora prior felon, but he doesn't have any exposure to jeopardy if the people wanted to retry him for that alleged crime, right?
Well, moving to vacate the conviction would be one way to get the relief as far as not having his risk level automatically jump from 1 to 3, okay? That also, vacating the conviction also involves resurrecting the prosecution.
Well, I just want to be clear, was your answer before that he could not vacate the conviction, that there was some procedural bar to
I
it?
believe because this defect is clear from the face of the record, that would have been a type of issue that he would have had to have raised on the direct appeal itself.
Didn't the resentencing court tell him he did have an opportunity to vacate the conviction? He just had to go, quote unquote, to a higher court to do it?
The county court basically said it did not have authority in the context of a resentencing provision.
That was
to
not the scope of the remand.
Yeah,
Right.
so he had no authority. If you want to try and vacate it, you need to go and
And if he had tried and been unsuccessful, let's say maybe he made it all the way up here and we didn't agree that he could vacate it, wouldn't that have strengthened his position to argue for the downward departure?
Well, if he would have went, say he did a direct appeal and he raised the same issue and he lost, Well, then we have principles of collateral estoppel that might prevent him from relitigating in the SORA proceeding, whether this was a coerced guilty plea or not.
Well, I don't understand why. You'd be in the same position that you are in now in terms of whether the conviction should be used for purposes of the board's assessment or not.
I'm not sure I understand.
I'm not understanding, Judge Rivera stated if, in fact, he had moved and he came up here and he lost, you're in the same position in terms of SORA, are you not?
Well, in his position is that he proved that this was a coerced guilty plea.
Right, so we're talking about moving to vacate after the county court had made a determination that he wasn't going to be adjudicated a predicate because of the coerciveness of the plea. So at that point in time, why did he not move to vacate the conviction?
I can't speak on this record as to why he may or may not, that he did not, but our position is that's not the only way for him.
But was there a procedural barrier to him doing so at that juncture? Without going beyond the record, was there?
I believe the procedural barrier would have been the fact that this should have been an issue raised on the direct appeal. His attorney never filed a notice of appeal. The appellate division denied his request to still file a late appeal, and that would be the procedural barrier. But it's our position that just because—
He didn't have an ineffective assistance of counsel claim on the failure to file the appeal?
On this—
Given that he was successful?
On this record, I couldn't say. It's unknown. But I guess my main key point is that just because there might have been a way for him to have avoided this jump from level 1 to level 3 by moving to trying, if he could have vacated the conviction on direct appeal.
And let's say he had for one moment. Could not the people have argued based on whatever record was created that nevertheless he should get a level 3?
Oh, absolutely.
Anyway.
They had, this was the establishment of the presumptive risk level. And
Aren't we just back to his real recourse, given the posture of the case and what the prosecution people could have done, a request for a downward departure?
I would argue that that's the people's recourse here because the override should not have been applied because it was an invalid, coerced conviction. The guidelines, to be rational, should be read like the guidelines expressly say that we are
Yes,
going—
but even assuming all of that is true, my point was, could they not have proceeded to request an upward departure? Based on whatever record is created regarding that particular prosecution.
The people could have moved—
And the defendant then would have sought a downward departure. Hopefully, counsel would have said, I disagree, no, they haven't met their burden, but if they have, I'm requesting a downward
or
departure.
defendant could have argued against the people's request for an upward departure.
No, I'm saying they could have done that, and in the alternative. We see that all the time, right? They make an argument on the merits of the points and so forth, and then say, but in any event, if the court is not in agreement, we want an upward departure if it's the prosecution, we want a downward departure if it's the defendant.
And all that would be resolved on a remittal by this court with a holding that you can't use a coerced guilty plea as a predicate for an upward departure because you're saying the mere fact of the conviction allows the jump from 1 to 3. We're saying that the guidelines can only be interpreted rationally if you go with what the board said in the guidelines, that YO adjudications and convictions can be used, that mere fact, because they are reliable indicators of wrongdoing, and there's a presumption of reliability. And if the defendant does not attack the reliability of the conviction, then the defendant's out of luck. The conviction is used and the override is applied.
That's the way it's written. A conviction is a conviction. There's not an allowance, as there is under an enhanced sentencing provision, to make a determination whether that was constitutionally sound, right? Like, there's different Doesn't that inquiry end there then?
I don't disagree with that. What I would say is that there's no deference to be given to the board. The board has never weighed in on this issue. Neither the correction law nor the guidelines deal with what do you do if the mere fact of conviction is based upon a coerced
Don't
guilty.
they weigh in by just using the term conviction and not having this language that Judge Singa says? Isn't that weighing in? They made a different choice here. It's conviction is
And
conviction.
that could have depended on the assumption that defendant could seek to vacate the conviction.
And also the fact that we're talking about SORA as a civil proceeding and not as a criminal proceeding, right?
Well, I would say that if a conviction is invalid and unreliable to enhance a defendant's sentence, which was the situation here, it shouldn't be used to increase the defendant's risk level determination based on the mere fact of the
But
conviction.
again, we're talking about enhancing a defendant's sentence for purposes of being a predicate or persistent. We're not talking about the sentence, we're not talking about the sentence in terms of the risk factor, in terms of the SORA determination.
That's true.
But again, don't you see a difference between the fact that we're talking about a civil proceeding as opposed to a criminal proceeding?
No, because we're still, SORA is based on reliability. If you have an unreliable conviction as a matter of law.
Okay, so what we're talking about, you state it's an unreliable conviction. It's a conviction. There's no issue. My understanding from the record is there's no statement that of actual innocence, that he did not, in fact, commit the crime, right? So he's not saying he's innocent. He's just stating that there was coercion in terms of the plea and sentence. We're back to a conviction is a conviction.
I would have to push back on that a little bit because I think there were statements made during the resentencing proceeding which clearly showed that Mr. Moss was maintaining his innocence.
Well, he could vacate the conviction and go back and litigate that, right?
Well, there's a procedural barrier for
And
him
then
to
if
do
he
that.
wins and vacates that, if he vacates the conviction even, there's a mechanism for coming in periodically to get your level reduced, and that would be a changed circumstance, wouldn't it?
I don't believe that vacating the conviction was a viable remedy for Mr. Moss. I would argue that.
Viable because, again, procedurally it's barred?
Procedurally, there's a procedural bar. Plus, our key point is the mere fact that that's available as a remedy doesn't mean that he shouldn't be allowed, as a matter of due process and under the statutes, to contest the reliability of the conviction that they're using for the override at the SORA proceeding. What relief did he ask for? He says, don't make me a level 3 based on a coerced guilty plea. That's what he was.
Sounds like a very strong argument for downward departure, especially if there's a procedural bar.
But
That doesn't fall on his shoulders, right? That in part the procedural bar is because of the attorney's failure to properly file a notice of appeal, or failure to file a notice of appeal.
yes, but our position is that the override should not have applied. The people still have the remedy of moving for an upward departure. Mr. Moss had the ability at that point to argue against it, maybe prevent it from going all the way up to a 3, maybe it only goes up to a 2, but that's our position, that a coerced guilty plea, unreliable as a matter of law, should not be used for an automatic override.
Thank you. And counsel, before you start, I forgot when we started the argument to announce that we're delighted to be joined by our colleague from the First Department, Troy Weber.
Still delighted.
Welcome, Judge Weber.
Thank you.
I was going to remind you of that. May it please the court, Marty McCarthy for the people. What we're talking about here is a conviction. So what we're focusing on is whether there is the fact that the conviction exists. The only time we look at reliability of the conviction is, as Judge Weber pointed out, is in sentencing proceedings. You cannot use a unconstitutionally obtained conviction to enhance a defendant's sentence.
But why should the people get a benefit off of a coerced plea?
Why should the defendant get a benefit in this scenario?
What's the benefit?
He avoids double jeopardy, for one, right? So he
But
has
what if
all the
he's-
protections.
What about this procedural bar? Do you think, maybe you disagree, do you think there is a procedural bar?
No. So
To vacating the plea?
no, the focus on due
Of the
process is whether the processes exist, not whether the defendant has availed himself of them. So the question isn't whether the defendant has the ability now to perfect the appeal. He doesn't. The question is did he have the ability to perfect an appeal? Could he have filed a notice of appeal on the 2007 conviction? That's what due process requires.
Okay, but his lawyer failed to do so, so that, you've got, and then the appellate division denied him the opportunity to file a late appeal.
But that is not, when you look at due process, you look at whether the remedies are availed. So we're pushing against each other on this
Well,
concept.
let me just, do you agree, or do you see it differently, that there's a procedural bar to the 440? Forget the direct appeal for one moment.
Okay, so you want, and that's where I was going to go.
Yes.
There's a 440 avenue, and the funny thing was.
No,
and
so you disagree with counsel?
I disagree because.
You think there is a path under
There is at
440?
least one procedural path, and that's
What is
all
that?
The 440 path,
Which could be brought in your view now.
correct.
That's an ineffective assistance claim.
And funny, we should bring this up because last argument, you posed a hypothetical. And that hypothetical was a discussion about whether the defendant was actually coerced by the hypothetical used. It was 40 years, the cap was 20, and they were offering him 10. I mean, that hypothetical kind of fits pretty neatly with what we have here. The judge threatened 50, the actual maximum was 25, and he was offered 7.
But the ineffective assistance claim here that might theoretically be brought, as I understood it, was the failure to file a notice of appeal.
Or that whether he was actually coerced into that guilty plea because his attorney didn't tell him about the maximum.
Well, either,
exposure.
whether he proceeded on that basis or not, wouldn't he have an ineffective assistance claim based on the failure to file a direct appeal in any event? Would it have to be the additional point?
So the question about the ineffectiveness goes to the question of whether, and I don't believe this court has addressed this issue. I think the last time you looked at it was Cyville, I believe, which was about a decade ago, about the concept of a defense attorney's failure to file a notice of appeal timely, and then that year in 30 days, I believe, that grace period that you have in order to file late notice of appeal. The court would have to sort of examine that.
But here you've got a ruling that says the plea was coerced, and you have a lawyer who didn't file an appeal off what was later determined to be, seems like something of a claim, right?
So let's talk about what was found. What was found was a substantial evidence finding, which is standard under a second felony offender for challenging the constitutionality of the conviction. Substantial evidence is not preponderance of the evidence, which is the standard in a SOAR proceeding. It's a lesser standard. So what the defendant was attempting to do here was basically trying to invoke collateral estoppel and say, hey, guess what? At that during the sentencing proceeding, the second felony sentencing proceeding after the remand from the Fourth Department, you found that the previous plea was coerced. And the court said, that's not exactly what I found. And what the court was signifying was that was under a substantial evidence standard. And the court actually, the judge, and that's because we do have the transcript, actually said substantial evidence. He said, I find substantial evidence that the plea was coerced. And so the application of a substantial evidence finding to a proceeding where preponderance of the evidence would control, you wouldn't be able to apply collateral estoppel in that scenario. That's, in essence, what the defendant was trying to do. And that's all the
So
proofs he
just
put
to be
on.
clear, what's your position on whether there's a path for the defendant to seek to vacate the conviction at this point, and if so, what is it?
Okay, so I'm going to answer your question, but then I'm going to push back on your question, because I should answer questions first before I push back.
That would be helpful, yes.
I understand. And I would invoke the example of Judge Garcia when he was discussing.
I'm just asking, is there, in your view, a path for him to vacate the conviction
My
now?
attorney, the judge misinformed me, and my attorney misinformed me of what my maximum sentencing exposure would be. Therefore, he was ineffective, and my plea was not knowing, intelligent, and voluntary. So the on-the-record stuff that happens with the judge, together with any off-the-record stuff that the defendant may be allowed to allege, if it were true, would be a path to a 440.
I thought what we were going with on what's procedurally barred is the argument, my attorney was ineffective for not filing a notice of claim, a notice of appeal in a case where I had not only a colorable claim, but a winning claim, as established by the fact that a judge subsequently determined that the plea was coerced.
I'm sorry,
But I think
cut you off.
that's the argument that we were discussing. Is
Yeah,
it
and
your
I'm-
position, is it your position that that argument could not be presented in a 440? Now,
Don't think that particular
Why
argument
not?
can be under Cyville. Which is, and it's been a while, and I'm sorry, I wish I'd read it before I'd come here. That line of cases that talks about an attorney's ineffectiveness for failing to file a notice of appeal. Because,
that's where no one knows the outcome, but here you do, because you've got the
you
decision.
do now.
Yes,
You didn't know
but that's the
that.
point.
So I don't know. I'm pleading ignorance here. My last recollection is that particular type of claim can't be made in 440. But assume I'm wrong and you're right, then his mechanism is a 440. But I don't think I don't know, honestly. And obviously, I would trust the fact that you would tell me I was wrong, and if I was wrong, I don't know.
So it's unclear. I just want to get back to Judge Halligan's question. I think your answer to her question that you push back on is ultimately, it's not clear whether he has an avenue to vacate the conviction at this point.
No, actually, I answered her question. My
Okay, so
answer-
what
was-
would he?
What was the answer?
Yes.
My
I didn't
answer to her
understand.
question is
Yeah, I
if the
think-
defendant can allege that his attorney, as well as the judge, misadvised him of his maximum sentencing exposure, along the lines of the hypothetical Judge Garcia posed in the last case, if that were the case, if that were true, he can bring this as a 440 claim. So I pled guilty because my attorney misadvised me of the maximum sentencing exposure, and the judge did the same thing.
So, I mean, he would relitigate the issue in the 440, right? Because there's already a determination.
But again, the other
It's
thing
because
you
you
have to-
say it's a different standard?
The
I'm
other
not
the other thing
clear.
you have to remember is it's a different standard.
Yes.
It's not only a different.
That's your argument. It has to be relitigated because it's a different standard.
No, yes, but let me finish that thought. It's not only a different standard for sentencing proceedings, it's a different standard, as you discussed in the previous case, to vacate your plea, right? So if you were to take a finding, if this scenario had been a scenario where he had somehow perfected or filed a notice of appeal and it's had dormant for a decade and a half, that finding in the 440, right, or I'm sorry, in the second felony offender litigation regarding the sex abuse first case, that finding that that statement may have been coerced, that itself would not have been enough to vacate his plea, because you would have had to consider all the other factors, because as you discussed previously, the improper articulation of the maximum.
Well, I just say it was more than that. It wasn't only that a misstatement as to what the maximum was. It was that if you don't take the plea, I am going to impose the maximum sentence. That was the coercion here.
But that's just one.
So that's even worse in terms of a finding perhaps ineffective assistance of counsel and not filing a notice of appeal after this is made known in terms of the constitutionality and the predicate felony status.
Yes or not, it's still one factor, and the court would have to weigh all those factors. That factor may weigh heavily and outweigh the other factors. But the point is, that analysis is more than just whether the statements were coercive. That's my point. Here, all we have is a finding that the statement was coercive. That's the only thing that was found in that second
Well,
felony
let's say
offender
we
proceeding.
let's say we agree to this extent with counsel, that if there's a finding by a court that the plea is indeed coerced, we don't want to dishonor that finding. We don't want to give any benefit related to a coerced plea, and so it should not be counted as a conviction for purposes of SORA. Don't you still have the opportunity to request an upward departure? Why isn't that the best approach?
When would we have requested, we did request an upward departure at.
But the court didn't need to do that because it went with the override. So I'm just saying,
But we- but we did.
Okay, I
Yeah.
understand. So my point, though, is if you still have that opportunity, should we agree with counsel that this particular, the plea, because it's found to be coerced, should not count for purposes of saying the conviction is reliable?
But you'd have to,
All
So
I'm
I-
saying
I-
is, why isn't that the proper approach? I mean, this seems to me sui generis. I hope this is not going on in every courtroom in New York.
I couldn't tell
There
you.
may be pleas coerced, but hopefully they're not, the defendants still have an opportunity to seek to vacate the conviction based on any alleged coercion.
You said opportunity. Again, that's what due process requires. Due process requires, was there an opportunity? The answer was yes. The fact that he didn't avail himself of that is a differ't problem. But when you focus, when you're looking
Okay,
at
but
due
let's go back to
process-
my question. Why
I
is
was
it,
going to. You distracted me.
why not just allow the people to be able to request an upward departure? Make whatever argument they want as to why the court should rely on the allegations and whatever other evidence you're going to present regarding the offense.
Because if you were to do that, you in essence saying that people can't use this conviction in the SORA proceeding.
Well,
And-
yes, that's my point.
Yeah, but, and I was restating your point.
Okay.
And I'm going to move on from that and say, you've never done that before. You haven't done it in a scenario of a special information. You haven't done it in cases where a felony is a disabling feature in a civil context, which is a civil proceeding. So anything where a felony would be a bar to employment, you've never done that before, right? You would be creating due process in a scenario where there was procedures available to the defendant at the time of. And so when you look at whether you should create that process, you have to focus on whether there were existing procedures that the defendant could have availed himself of. And the answer is that, and I think I'm beating a dead horse on this, is yes, there were. So when you focus on due process, that's his claim. His claim is due process requires this. And my answer to you is, if due process didn't require that in a special information context, when you decided in People versus NAC, it can't.
Well, I thought, at least in part, his argument was if you're interpreting the guidelines, you cannot read this conviction as the conviction that is intended under the guidelines. What's your response to that?
My response to that is a conviction's a conviction.
But
The
why
most-
is it reliable if it was not a constitutionally obtained conviction? Usually we think about those as in mutually exclusive buckets, it seems to me.
So when we talk about reliability, going back to second felony offender, persistent felony offender sentencing issues, we're concerned about enhancing a punishment using something that was.
Yeah, but in what way set to the side those provisions? In what common sense way is the conviction reliable if the plea was unconstitutionally
Because
obtained?
it still exists.
That's not the question. The question isn't does it exist? The
No.
guidelines say, if I can, the guidelines say is it's supposed to be a reliable indicator, right?
Yeah.
So how is it reliable if it's not constitutionally obtained?
Because because the conviction still exists, because the conduct underlying the
I just- it
conviction was
seems to me-
admitted to.
in a plea that was unconstitutionally obtained. So I'm just trying to understand how existence and reliability are synonyms.
Because when we look at the sort of the ultimate indicator of reliability, the defendant did nothing about this conviction. Why didn't he do anything about this conviction? Because he got a really good deal, right? That, to me, is the most reliable indicator that he was guilty of the conduct. That's the focus. And again, when we
Would you
talk
feel
about-
differently if he, I understand your position, but let's just go with the hypothetical. Would you have a different response if there is absolutely no path to vacate the conviction?
Okay, so good question. Let's foreign country, right? Maybe the conviction happened in a foreign country, and the foreign country didn't have any of the due process trappings that we have here. Then that might be a different story, right? So, and I can't think of one off the top of my head. I can point you to the Fourth Department had actually dealt with this particular issue in Thailand. And they did an analysis of whether the procedures, and I can give you the site. I kind of was sitting in the attorney lounge, really bored and wanting to find cases that I can cite to you at oral argument. It's Board of Examiners of Sex Offenders versus D'Agostino. It's 130 3D 1449. It actually cites the People versus NAC, and it does this analysis. It first holds that due process didn't require it, but then it goes further to actually do the analysis that you're talking about. Were there processes in place in Thailand? And they didn't just focus on his appellate rights. They also focused on the trial itself. Was the trial fair?
And what they decide?
They ultimately decided in that case that he did have at least one alternative to address the conviction. And when they looked at the specific trial issues, they looked at, I think it was like a confrontation issue, and found that we had a similar rule in New York. So that the trial itself was not an unconstitutional obtaining of that conviction. But that's just an example of where that did happen. If there was a country where it didn't, then maybe this would be a different story. He didn't have a right to an appeal, and at trial, you're allowed to use hearsay, and there's no confrontation, or basically a summary show trial where there's no evidence presented at all. That might be a different story, but that's not what we had here. And then maybe if that case came before you, then maybe you'd have to contemplate creating a due process remedy for that particular defendant.
Thank you.
But that's not what you have here. Any other questions?
Thank you.
This court doesn't need to create any due process remedies. The conviction that was found to be a coerced guilty plea, that ruling should have been applied in the SOAR context. When you use a coerced guilty plea for an override, there's 3 errors. You're violating legislative intent because as this court has said over and over again, the intent is to have accurate assessments of an offender's future risk. How can you have an accurate assessment if you're relying upon unreliable evidence?
So is every SORA defendant that's subject to an override entitled to a hearing to determine the constitutionality of the prior conviction?
If that defendant raises a Diaz claim, this court in People v. Victor Diaz said that there's a distinction between accuracy and sufficiency. If you don't raise a challenge to the accuracy of the underlying conviction, it's going to be held sufficient and the override's going to apply, which is going to happen in a vast majority of cases. This is a unique situation. This is a case where Mr. Moss proved it was a coerced guilty plea. It was unreliable as a matter of law. Treat it like you would treat a coerced confession. You can't use it for any purpose.
Well, you can't use it for an enhanced sentence purpose, and that's explicit in the legislation, but it's not so under the guidelines and under SORA. So what are we to make of that?
We have to read the guidelines so that they don't violate legislative intent. We have to read the guidelines so that it doesn't violate due process.
So could legislative intent override the text of the guidelines or statute?
The guidelines say you can use a conviction which we assume is a
Does
reliable.
it say that? It says we
Yes.
assume it's reliable in the
Yes,
guidelines?
in the guidelines, it
says-
says the reason you can use a YO adjudication, which is not a conviction, and convictions are because those are reliable indicators of wrongdoing. You can, from the mere fact of the conviction, you can make a rational conclusion that the defendant committed the underlying acts.
Well, that was my question before. Why is it, again, that it was coerced, that the plea was coerced or found to be coerced? Why does that mean that the underlying acts, that the defendant did not, in fact, commit the underlying acts? I mean, I know you stated that at some point he stated that he did not commit the crime, or he wasn't guilty, or he was innocent, but I don't see that in the record.
There's stuff in the resentencing provision where he made claims the DNA test was not a match. There was other things where he said where he was asserting his innocence. But I don't think that's what we need to show here. We need to show that it's an unreliable conviction. They can't use the mere fact of
So how are you defining unreliable? Or is there anywhere in the statute that defines unreliable?
I have to fall back and say.
Does
that-
unreliable mean because it was coerced, or is it unreliable means because the actions that the individual is stating that he or she did not commit the actions?
It's unreliable because most defendants, if they're threatened by the judge to do the maximum time.
Well, hopefully most defendants are not threatened by a judge.
I would agree with that, hopefully not. But in that situation, there's a substantial risk the defendant's going to admit to conduct that he's not guilty of because he doesn't want to spend 50 years in prison.
Counsel.
I see my lights on.